Good afternoon, and are we ready to go through the prospective jurors and do our strikes? No. In open court. I'll start with the state. Do you have any people that you're seeking to have stricken for cause?
We would, Your Honor. We would move to strike P67 for cause.
Okay. First, let me ask before we go into any argument about it, is there any objection to striking P67 for cause?
I believe that he was rehabilitated and should be having a hardship, so if that's an objection, I guess, yes.
Okay. State, want to respond?
Yes, Your Honor. My reasons for cause, number one, is the letter that he had his wife write for him, as he expressed. In that letter, he expressed several reasons why he felt it would be a financial hardship and also a hardship with his family. He also, by the way, acknowledged when questioned that he had access to the internet, violating the court's instructions, that he had no contact at all or attempt to find out anything about the case. Now, he stated that I believe his daughter or a relative is the one that brought it to his attention, but he still was aware of what was put on the internet by apparently one of the TV stations regarding this case. And the final thing is that my impressions are that his understanding of the English language is limited in the fact that he had to have his wife write for him how to express himself in terms of the reasons why he felt he would not be able to sit as a juror. And so related to that, I think he would have a hard time being able to exactly...
Can I stop you for just 1 second? Mr. Zimmerman, can you hear?
Yes.
Okay, I just wanted to make sure that you can hear the arguments that are being made. Go ahead.
He also stated that in terms of being able to communicate with the other jurors, I think based on the fact that he had to have his wife write the letter just to express himself as to this thing, I think it presented a hardship to everybody involved in terms of being able to have him sit as a juror and actually comprehend what's going on and communicate with the other jurors. He also referred to this was a nightmare for him in terms of the experience. So a combination of those three things, financial, family, and the fact that I was submitting disobeyed the court's instructions already about having access to the internet or being exposed to stuff that's occurring outside the courtroom, and then the fact that I think he suffers from a ability to understand or comprehend completely the English language.
Okay, Mr. O'Mara?
Yes, he's been here for years. I didn't notice any difficulty with him understanding English language, with communication with any of us, and we went into that yesterday, went into it again yesterday afternoon, and had the opportunity, you know, if we needed to go into it more today. So the language, I think, is simply a non-issue. I think what probably happened was his daughter said, "Papi, they called you a Mexican," or they said you're a Mexican, which is the only thing he said that was done. It's not a violation of the court order at all. And had that been inquired more, we might have found out more about it, but I didn't consider it anything more than an incidental, something about him being Mexican. So that's not an issue. And the hardship, we vetted it out yesterday, and it's going to be difficult for everybody, including him, and strangely different than other people who we decided are not hardships, like the young girl who does live with her mom but was not going to get paid at all. We decided that wasn't a hardship, and he's getting paid for the next 30 days or 30 days from last week. So as far as it being an economic hardship, I just don't think it rises to the level, and I don't think that we should just build more on top of the other little concerns to suggest a cause concern. He said he would be a good juror, said he wanted to serve, and his concerns are not insurmountable.
Okay, Juror P67 had never given any indication to the court or to counsel that he couldn't understand the proceedings or what was going on. I'm not going to excuse him for cause. Anybody else that the state is seeking a for-cause strike on?
No, Your Honor.
Anybody from the state? The defense seeking a for-cause strike on any of the potential venire?
No, Your Honor.
Okay, thank you. So then we'll go through the one by one. Does the state have any objections to Juror B12?
We accept, Your Honor.
Defense?
I'm sorry, Your Honor. I was completely ready, except my chart just got something.
Well, then take your time.
1 second. Thank you, Your Honor, I apologize. And I am ready, Your Honor.
Okay, the state does not have a preemptory for B12, does the defense?
No, I did not, Your Honor.
Okay, next one is B29. Any objections or preemptories from the defense?
No, Your Honor.
From
No,
the,
Your Honor.
okay, from the state?
No, Your Honor.
Next one's B76. Any preemptories from the state?
We accept, Your Honor.
Defense?
As do we, Your Honor.
Next one is B7. Any preemptories from the defense?
No, Your Honor.
From the state?
We accept.
B35. Any preemptories from the state?
We would strike, Your Honor.
Next one is B37. Any preemptories from the defense?
No, Your Honor.
From the state?
No, Your Honor.
B51. Any preemptories from the state?
No, Your Honor.
From the defense?
I'm sorry, just a moment.
Yes, you may have the time.
And it is, Your Honor, just going through, I'm sorry, B51 to me as
Yes.
far as the potential.
Right, do you have a preemptory strike on B51?
Can you just a minute?
Okay.
That is accept, B51 is acceptable. Your Honor.
Okay, the six we have at this time are B12, B29, B76, B7, B37, B51. Any backstrikes from the state?
Can we have a moment, Judge?
Yes, you may.
Thank you. All the way through B51.
The ones that we have are as follows: B12, B59, B76, B7, B37, B51.
Judge, I think it's B29. I think you said 59.
I said 50, I said B, I did,
B29, right?
B29.
Okay.
B12, B29, B76, B7, B37, B51.
Okay. Thank you. If I could have another one.
Yes, you may.
May I have a green sleeve, Mr. Your
Yes, you may.
Thank you. Okay, hold on. B76, Your Honor.
Does the defense have any objections or a preemptory challenge for B86?
No, Your Honor, we accept.
State?
We would strike B86.
State have any preemptory challenges for juror E6?
We would strike juror E6.
Does the defense have any preemptory challenges for juror E40?
A moment, if I might.
Yes, you may. Okay, does the state have any objections or peremptories for E40?
No, Your Honor.
The six we have at this time are B12, B29, B7, B37, B51, E40. Any backstrikes by the defense?
Yes, Your Honor, B7.
Okay. State have any peremptory challenges against E54?
We accept, Your Honor.
Defense?
We accept them.
The six that we have at this time are B12, B29, B37, B51, E40, E54. Any backstrikes by the state?
Have another moment, Judge.
Yes, you may.
Okay, so we're on B12, Your Honor.
Okay, then, defense have any peremptory challenges against E73?
I have a moment, Your Honor.
Yes, you may.
Your Honor, I would ask that the state identify a race and gender neutral reason for now having struck 4 white women in a row. And I would ask that the state be required to address that issue. As to
First, can I
why-
have your answer as to E73, because that was the question, and then I'll go back to that.
I'm sorry, I just want to make sure that wasn't waived. B73 would be acceptable, Your Honor.
For the state?
We accept, her.
Okay, then please indicate the ones that you would like a race-neutral reason for, or
Well-
a gender-neutral reason for.
At this point, they have now stricken 4 white women in a row, so I guess I'll
I
ask.
understand that. What are the numbers that you're challenging?
I'm sorry. B12, B86, E6, and E76. I'm sorry, B76.
I'm sorry?
B as in boy, 76.
So B12, B86, B6, and B76?
There was a E as in Edward 6.
E6. Okay, let's start with B12. Mr. De La Ronda?
Yes, Your Honor. May I remain seated, or is it?
You may remain
Thank
seated.
you, Your Honor. As to B12, we struck her because of comments she made, specifically that she had actually gone on the Zimmerman's defense fund, went and looked at but did not give any money. She heard the defendant and his wife had a defense fund and they used it to pay bills. She also, by the way, has a warrant of limited extradition pending at this time that the defense is aware of.
Okay. Response?
Pretextual, the fact that she saw a website, did not donate to it, noticed that it was out there, which has been general public knowledge for 16 months, is not a valid reason, and gender-neutral reason. It's merely pretense for a basis for striking a white woman.
Okay, I think the reasons given by the state are not pretextual and they are genuine, so that strike will remain. Let's go on to B86. Mr. De La Ronda?
B86 is B86 said Trayvon, as she described it, Trayvon Martin was expelled from school, and if it hadn't been out here, it wouldn't have happened. If he hadn't been out there, it wouldn't have happened. She said the sequestration also would be a serious problem. She's a school office worker, and in our opinion, she stated she thought she had made up her mind, but in terms of whether going back. The main reason is, Your Honor, that she's aware of in her claim that the victim was expelled from school. And obviously, she said she could disregard it, but our position is that that fact, while in her mind and she thought was relevant, even though she was honest, is relevant in the sense of we're concerned that in the back of her mind, when she goes back into liberated, will enter her equation. So that's something that the jury, we believe, will not be informed of. The court's rulings so far are indicated that she will not be, that the jury will not be informed of that.
Okay, response?
Pretextual, Your Honor, unless the standard is now going to be that anybody who heard anything about this case would then be removed for peremptory without challenge. She said something. She also said that she can put aside all information that she heard outside the courtroom and leave it outside the courtroom.
Well, okay, go ahead.
And unless that evidence shows up in the courtroom, it's not going to become part of her consideration. So the fact that she said that she knew something about Trayvon Martin's school status and yet would be able to set it aside is not a gender-neutral reason. It's just suggesting any factoid whatsoever would exclude her. I don't think that's proper. Particularly, Your Honor, and I know that we have to do this individually, but in context that every strike, the past 4 were white women.
I understand that, but the court also understands the makeup of this entire panel is a majority of women, and that's a possibility that would happen. There's just almost twice as many women on this potential venire as there are men. So just statistical numbers, that's likely to occur. I don't consider that to be a reason. So you're saying that it is pretextual because of, what is the pretext?
Well, the pretext is suggesting that a factoid in and of itself is a reason to exclude. And there have been dozens of benign men and women who have had certain information about the case. They all sat through the voir dire, and others of the witnesses, other jurors who have been passed and accepted have evidenced knowledge of certain factoids of the case, and that made it through. So well,
they made it through based upon both sides agreeing to have them make it through for cause challenges. And the state isn't at this time making this a cause challenge, they're making it a preemptory.
The record should be pretty clear that B86, I believe, was one, I think the only one that talked about the school records. There may be one other one that we haven't gotten to, but I believe she was the only one that referenced the school records or the victim being expelled from school, as opposed to the other ones that talked about facts that they were aware of. That fact itself is, from our opinion, prejudiced the state's case, and that fact should not come in at all, and that would interfere with us being able to get a fair trial. And she's a school disciplinarian, so to that, it's more of a relevant issue in terms of her emphasis on that point.
Okay, the court is going to make a finding that this preemptory strike is gender neutral, it is not a pretext, and the reason given by the state is genuine, so I will allow the strike. Let's go on to E6. Mr. De La Ronda.
We're concerned in terms of her reaction throughout in terms of these, her concern about her kids being sequestered. She also mentioned several, I think at the very end of Mr. O'Mara's questioning, that innocent people go to prison. She was the one that stated that, not Mr. O'Mara asking her, but she herself had stated it. We're concerned that she's going to be focusing on the penalties aspects of this case that are irrelevant and they should not be considered by the jurors.
Mr. O'Mara?
I just have the same concern in context of the other three, that though jurors have given opinions, that we have to look at it and see whether or not it is pretextual as a reason for the state striking through 4 white women, being able to come up with any reason. You have to look at it and say, in the context of what has been allowed, we had other jurors who have had information about the case, have expressed opinions about the case. For example, the 7th was on the panel and not stricken by the state at first, because, and even though he had concerns about applying the law. This woman now has said, sometimes we have to be careful because innocent people go to jail. That's a concern we want a juror to have. So to use that as a basis for a strike is protection.
Any response?
Judge, as the court, I believe, already notated, in terms of on that front row, I believe the majority, if not almost all of them, are white women. There's 4 women still left in the jury.
Okay, we've gone through the first 12. I don't have indicated on my notes here whether they're men or women. So of the first 12 that we have gone through, can somebody tell me from their notes how many of them were?
I can tell you everybody's, there's a white, B12 is a white woman, B29 is Hispanic or black woman, B76 is a white woman, B7 is a white male, B35 is a black male, B37 is a white woman, B51 is a white woman, B86 is a white woman, E6 is a white woman, E40 is a white woman, E54 is a white man, and E73 is a white woman. I apologize if I went so fast there.
So of the 12 we have gone through, the first 12, 8 are white females, white women.
Half of whom have been struck by the state.
And so has, out of those, we have, I'm just going to go males, not what their races are. We have 1, 2, I guess there would be 4 males. Well, there was a black woman. So 3 males on there, which 1 has been stricken by the defense, and 1.
The state struck one.
So there's 2 out of 4, and there's 4 out of 8.
4 out of 5 strikes by the state have been white women. That's probably the most significant.
Well, I guess my point is, what I'm trying to say is, out of 12 people, 8 of them are women, twice the amount of men.
Yes.
So statistically, you're going to have that. If you're going to have, you each are entitled to 10 strikes. So if you were to have stricken the first 10 people, for whatever reason, you would have stricken 1, 2, 3, 8 out of 12 white are women.
Correct.
So
Not all white, but women.
7 out of 12 white women.
And then it would be an inquiry as to whether or not he did that for gender neutral reasons. And we would look at all of my strikes in context and wonder if there is something to the system of removing white women from the jury, which is exactly what I'm asking you to do.
Okay, I'm going to come back to E6. Let me hear the reasons for B76.
B76 is one of the responses that she gave. She asked, why was the kid, to quote her, why was the kid out at night getting candy? And so we're concerned in terms of her forming impressions already in terms of why Trayvon Martin making a big deal of the fact that he just went to 7-Eleven to get candy. She was the only one that articulated that. And so because of that, we're concerned. Also, I believe at one point she was asked in terms of who she knew, and she misidentified one of the black female spectators as being the victim's mom. And for those 2 reasons, we feel that she would not be a fair juror to us in this case.
Okay, response?
Response is that, once again, the state is saying that because they know one factoid, because they said, I wonder why Trayvon Martin was out getting candy, maybe thinking it was at midnight at 2 o'clock, which of course they will be dispelled of with the facts of the case when they find out it was at 7. They're using that factoid to say that as the 4th of 4, that we're not just striking white women because they're white women. And they're suggesting that because she said, well, maybe one of the people out here is somebody else, is that, as though that would have any relevance whatsoever to the case, that's another pretextual reason. This one is probably the strongest pretext.
76, she will remain on there, so that's one less strike for the state. And the same with E6. So the state is at 3 strikes, the defense is at 1, and we have 1, 2, 3, 4, 5. Well, our first 6 are jurors B12, B29.
I'm sorry, Ron.
I'm sorry, B12 has been struck, I'm sorry. B29, B76, B37, B51, E6, and E40. Any backstrikes by the defense?
My, a moment, Ron.
Yes.
My client can visit with me over here. So we can
Yes,
go over
mhm.
together. Thank you. that 6 was acceptable.
Do you have any back strikes to those 6?
We do not.
Does the state have any back strikes to those 6?
And I apologize, can you tell us again who we have on the jury?
Yes, we have B29, B76, B37, B51, E6, E40.
We would still like to, I know the court's ruling, but just for personal record, still like to strike E6 and B76, but we understand the court's ruling.
Okay, any other back strikes?
No, Your Honor.
Okay, then we have those members of the jury. Then we're going on to our 4 alternates. Both sides had already accepted E54 and E73. The state have any objections to M75?
No, Your Honor.
The defense?
I'm sorry, the first alternate you identified was,
E54?
okay, and then the next one you want to select.
E73?
And is that the question to me now?
No, the question is, do you have any preemptory strikes to M75? I'm going to go through the 4 and I'll allow back strikes, but right now we're on M75.
Yes, I would strike M75.
The state would raise the Neal issue as to M75.
Okay, what is your race-neutral reason for striking M75?
For the record, she is a black female.
Yes, Your Honor. There was a concern, as we looked into it, that she is a good friend, co-worker, Facebook friend of a witness in this case by the name of Wes Robinson. We had asked her about that, but any friends she knew or whatever. It was put on the witness list, which she reviewed and did not disclose it. The concern I have is that some of the Facebook postings suggested a lot of interaction between the two, and I'm just very concerned that, 1, that it exists, and 2, that it was not acknowledged.
Okay, state,
I have not seen anything to reflect that she's a close friend.
do you want to show whatever information you have to the state, please?
This I have a moment to show this.
Yes, you may.
And you'll also remember another concern along with the Facebook was that this was a woman who had actually posted her jury summons online on her Facebook, which was then available to Mr. Robinson and others.
Being stricken. State have any objection, and we're still in the alternate one for B61.
We would strike B61, Your Honor.
Defense have any objections or strikes for B72?
No, you won't.
The state?
No, Your Honor.
The state have any preemptory strikes for E22?
No, Your Honor.
Defense?
Yes, we would strike E22.
Defense have any objections to, oh, sorry, go
I
ahead.
apologize. We would raise Neil and Melbourne challenge as to E22.
Okay, what is the race,
She's a black female for purpose of
right,
record.
the race-neutral reason for wanting to strike E22?
I might have a moment to state
Yes, you
wrong.
may. Yes, you may.
As far as the race-neutral reasons, Your Honor, she had mentioned that, of course, she was a church administrator for the First Unitarian Church. She's been there for 19 years. She suggested that she heard about it in the beginning and even said that she thought the police should have been more active. And then suggested basically that her knowledge of the facts of the case was that a lady heard someone got killed. Those are my notes, referred, of course, to yours, and the state will suggest, but here's the concern that I have, that the pastor that she works with every day for the past 19 years, the pastor's actually been there for 4 years, but she's been at the church for 19 years, wrote quite a pointed letter to, and I'll bring this up to you in a second, if I might, quite a pointed letter that was actually identified and written, published in the Orlando Sentinel, which was very pro Trayvon Martin and very sort of anti, well, I'll let you review it, but showed a very, very specific point of view on the case. Then we also have a sermon given by that same pastor at the church, which evidences again, and appropriately so, that they were strongly in favor of the Trayvon Martin side of the event, and talked quite in detail about the significance of the event and how they needed to make it significant and make a stand on this event, referencing, of course, to such luminaries as Martin Luther King, Theodore Parker, who was a 19th century Unitarian preacher, mentioning, of course, slavery and other matters in the sermon given. And then we have documentation concerning their group, the Florida Unitarian Universalist ministers, actually filled out and wrote a statement on behalf of the Trayvon Martin case. I'll defer to your reading of it, but it is, of course, and as is appropriate for a person's First Amendment rights, to be quite vocal in their concern about the case. We then also have additional information published by the church at which she's worked for 19 years, talking about Trayvon Martin and the path forward, and focusing primarily on such matters as George Zimmerman called 911, expresses worry about those people always getting away. Of course, that's not what he said on the text. I don't know that you know.
I don't need to get into that, just continue with your proof.
Okay, so, well, the reason why I mentioned that is because it is a very inflamed view of the evidence that was made a part of the church's presentation to everyone who's a part of the church. And then also, again, talks about research on that the church performed in its support of Trayvon Martin. So, in sum, the concern that I have is E22, who evidenced little knowledge about the case and less opinion, has not been straightforward in the influence that she was under based upon the extraordinarily activist role that her church, her pastor, and basically, again, where she spends 8 to 10 hours a day, involve itself in. And I'd like to approach the bench if I might.
Thank you. State.
Just because one is a member of a church or works at a church, it doesn't mean that the person authored. First of all, there's no record, and nor, I believe, is Mr. O'Mara implying that the juror, E22, authored any of those documents. Nor, I believe, was she asked about it. I think, quite frankly, she was very frank in her knowledge of the case and extensively was questioned about that. She wrote it on, in terms of on her jury questionnaire, and then was quizzed or extensively questioned by both sides as to her knowledge of the case, her opinions, and the bottom line is she said her opinion, she had not formed that and could keep an open mind and had not formed an opinion as to guilt or innocence. I think because one is a member of a church doesn't mean that necessarily that person can be fair. I, for instance, I'm a member of the Catholic Church. The Catholic Church, at least in the United States, I believe throughout the world, does not believe in the death penalty. I firmly believe in the death penalty. So the fact that one is a member of a church, I don't think by itself means that that person has acknowledged or taken something that somebody else wrote, the pastor or a sermon he gave, which I don't think was anything inflammatory other than their opinion, that means that that person should be stricken for cause. Or I'm sorry, preemptive challenges. I think this is pretextual on the part of they're just trying to strike her because she's a black female.
My response?
Yes, you may.
The issue is not whether or not she belongs to a church. The issue is not even whether or not she has a strong opinion that may not have been properly presented here today. I consider her to be somewhat stealth in that sense, in that we did question her extensively, and I knew that this information was out there, not all of it, but we knew that any person who is a church administrator, which is literally second or third in line to a church that has that much of an influence on it, I don't think that she properly presented. But that's not even the issue. The issue is whether or not this information that I've given to you not having been disclosed by this juror in voir dire where she was asked about it, if that information is race neutral. Now, you can go beyond it to say, I'm just making a pretense because I want it off because she's black, but you have to first look and say, is that information, that amount of information influenced by the place where she works, not identified in voir dire, is that a race neutral reason? And I would suggest, Your Honor, that it is.
With all due
And I
respect,
didn't know that we were going to, how many times we were going to go back and forth.
with all due respect, this juror was not asked specifically about this. She was very frank as to where she worked. She was not given the opportunity to be asked about that and express whether you agreed with it or not.
Well, I think that all the jurors who were individually voir dired were asked extensively by both sides if they had any information or had anybody spoken to them, either friends, family, at work. And I don't remember if it was specifically juror E22, but almost to all of them, they were asked if they belonged to any churches and was that brought up, and she did not respond. And had she responded and said, this has been brought up and I have heard it and it was discussed, but I can put that out of my mind and set it aside, the court would not be concerned. But the fact that it was not brought up is of some concern, and the court's going to find that that is not a pretextual challenge, and the reason given for the non-pretext by the defense is genuine. So I will not strike I will allow the strike of E22. Defense have any objections to E13?
No, Your Honor.
State.
No, Your Honor.
The four we have for our potential alternates are E54, E73, B52, and E13. Any backstrikes by the state?
May the court read those as
Yes.
E54?
E54, E73, B72, E13.
No, Your Honor, that's acceptable to the state.
Defense?
Just one moment, I'd like to go over with my client. It's acceptable.
Okay, so our alternates would be, counsel want to approach just for 1 minute?
B73 as the fourth alternate.
Any objections from the state?
No, Your Honor.
Okay, that moves us to E28, any strikes by the defense,
Depends, no, Your Honor.
by the state?
Have we got a vote, Your Honor?
Yes, you may. Okay, so the alternates would be juror E54, B72, E13, E28. Any backstrikes from the state,
No, Your Honor.
from the defense? Sure. Strikes left.
Oh, okay, I was thinking,
No. No strikes.
All right, and just to make sure that we're clear, because both sides do have strikes left, I'm going to announce the 6 members of the jury and the 4 alternates. The 6 members of the jury are B29, B76, B37, B51, E6, E40, with our alternates as E54, B72, E13, and E28. And you can have a moment, but I'm going to ask if there's any backstrikes requested from the state and then the defense. Let me know when you're ready. Yes.
we would just, again, move to strike E6. I know the court has made a ruling, and I don't mean to quibble with the court, but the additional grounds we would be concerned about is that she did know Dr. Danziger, who was a defense witness.
That's all right, I don't think he minds.
I apologize. He's a potential witness in the case, an expert, and we're concerned in terms of her relationship or ability to be fair in terms of having known that particular witness. So in addition to what we've already stated, we would have that as another reason why we would be concerned about this jury.
As just a quick response to the only addition, what she said when she looked at the witness list was that she recognized the name somewhere. She'd never met him, never been to him, doesn't know. I think she called him a physician, not even knowing that he is not, well, he's an MD, but he's actually a psychiatrist. Didn't even know him or what he does, so it really wasn't much of a concern, and she didn't even know what he did, just recognized the name.
Any response?
We're still concerned with the fact that I thought she said she knew him, but I may be wrong.
There was two of the, there was actually 4 people that she had indicated that she recognized their names, and when questioned, the ones she recognized were the ones that you just spoke of. Then the couple numbers down with the initials DD. She said she recognized on the last page with the initial last name W, first name N, and last name Z, first name S. And she said those were names that she recognized, and that was just she did not indicate that she knew them individually.
And just as to those, of course, we know the last two, they're notable names, and the third one, DD, actually should not have been on that witness list because we removed her from our witness list, so that was superfluous anyway. So we're clear, that witness is not testifying.
I understand what the state is saying, and I am not, I don't know how to word this. It's not that, I think if there's any doubt, that the doubt should be to grant the strike. So I'm going to stand by the strike. Are there any, not allowing the strike. Are there any other back strikes being requested by the state?
No, Your Honor, based on the court's ruling.
Okay, thank you. How about from the defense?
No, Your Honor, thank you very much.
Okay, Mr. Zimmerman, if you'll please stand up, sir. Mr. Zimmerman, you have had an opportunity to be with us since June 10th when we started the individual voir dire, and now today, the what I would call the traditional voir dire. Is that correct?
Yes, ma'am.
And you have also had the opportunity to look at all of these prospective jurors' questionnaires that they have filled out?
Yes, Your Honor.
And you were in the courtroom listening to the questions posed to them and their answers?
Yes, Your Honor.
And today you had the opportunity to see all the 40 potential jurors sitting in the courtroom together, correct?
Yes, Your Honor.
And you were able to listen and take notes in regards to the questioning and answers given yesterday and today?
Yes, Your Honor.
And you've had an opportunity to talk to your lawyers during the process and again during the lunch period about which jurors you would like to have on the jury or which jurors you would rather not.
Yes, Your Honor.
And you've heard the decisions and the strikes made in this case by your attorneys.
I'm sorry.
That
Yes, Your
Mr.
Honor.
Manti was in my way. Yes, so thank you. And is the decisions made by your attorneys acceptable to you?
Yes, Your Honor.
And the jurors that I announced, were you able to hear the 6 members of the jury and the 4 alternates?
Yes, Your Honor.
And is this jury panel acceptable to you, sir?
Yes, Your Honor.
Okay, please have a seat. What I would like to do is, you're getting your witness online. Can I have the ones that we're not taking? I want to see first the ones I'm going to dismiss. So if you could keep B29, I'll write them down.
You want to ask? Sorry.
No, just give me one moment,
Sure.
please.
And Representative.
I'd like to take the... And do I have an agreement from both sides, since we have a jury, that the court can dismiss all the other potential jurors that are on standby?
Yes, Your Honor.
Yes, Your Honor.
Okay. Here you go, Trish.
If I might, Your Honor, I'm just going to mention that now might be a very good time to remind us all that all of the information that we've been using for the voir dire process, all the information about the jurors needs to be protected, secured, shredded, something so that it doesn't get out.
Okay, I will ask counsel to please keep those secure. What the court intends to do with all the juror questionnaires is to file them under seal in the court file to be opened at a later time upon hearing before the court. up on there while I have them come in here, correct? I'm having the different jurors
No,
come.
I'm not gonna,
Okay, thank you.
just want to make sure you got down to the point.
They're not our 10, right? The 10 are, okay, thank you. I don't want to dismiss one of our 10.
Jurors are present.
Okay, please be seated. Ladies and gentlemen, I can't begin to tell you how much we all here in this room appreciate your patience during this last week and a half. You have been wonderful, you have been patient, you have been cooperative. The way you have entered and exited the courtroom, how the deputies have gotten you to light up, and your performance was just, it was wonderful. I'm now here to tell you that you are dismissed from your subpoenas, your jury summons. You are free to go. You don't have to listen to another instruction from me. You are free to read, write, listen to, get on the internet, and do anything you want about this case or anything else. You also are free to talk to anybody if you want to, but you don't have to. If you don't have to share your experience, or you can, that's going to be left up to you. Again, on behalf of the attorneys and the parties and myself, I thank you very much, and this will be the last time I have to dismiss you from the courtroom and tell you to follow Deputy Jarvis. Thank you again. Thank you. Please be seated. We're going to be bringing in the 10. When I tell you to, can you hand this to them? When I tell you to. Trish, I'm court to instruct the preliminary instruction today or wait until right before opening statements?
But before opening statements, fine.
That's fine.
Okay. Please be seated. Well, and except for those of you who are now just seated, if you'll stand up and raise your right hands to be sworn.
Raise your right hand, please. Do solemnly swear or affirm that you will well and truly try this issue between the state of Florida and the defense according to the laws and render a true verdict, so help you God? I do. Thank you.
Okay, thank you. Please be seated. Ladies and gentlemen, you have now been sworn to be the jury in this case. Deputy Jarvis has handed you a packet. It includes a cover letter and some things to assist you regarding what sequestration will mean. At this time, in just one moment, I'm going to have you go back into the jury room, and the sheriff will be back there to give you the instructions on the balance of the sequestration. I will have no further contact with you, neither will the attorneys, until we meet for Monday morning at 9 a.m. for opening statements. Okay, so if you'll please follow Deputy Jarvis out of the room. You could be seated, I'm sorry. Thank you. Do you have Mr. Owen available now?
I do.
Does anybody need a brief recess?
I'll
Or
need maybe 5 minutes to set up the screen and projector. Otherwise, he has already contacted and is waiting to testify.
And a few more than that, I need to come downstairs and grab something, and there's some travel time involved.
Okay, we will take a 15-minute recess and make sure that he's up and running when we come back. Court will be in recess.